appeal in the matter of Alize 1954 and another, and Allianz and others.
My Lord, I represent the appellant owners in this matter with Mr. Carlos behind me, and Mr. Russell and Mr. Coffer represent the respondent cargo interests. My Lords, before I go any further, can I just deal with a little bit of housekeeping in relation to the authorities bundles? I've handed up to your Lordships, as they should be on your Lordship's desk, some updates to the authorities bundles, and if I can just go through them with you. There is a new index for files 1 and 2.
Hang on a moment, Mr. Hill. Yeah.
So you should have a new index for files 1 and 2, and then you should also have a further extract from Scrutton, which goes into the back of tab 43, and that's the second authorities bundle. Tab 43.
43.
That's right.
I've got 49.
Yes, but before that you should have an extract from Scrutton in the bundle that we've just handed up, which goes into the back of tab 43.
Page 379, is that Scrutton?
Page 379 and 38.
So that's in tab 43.
That goes into the back of tab 43. While I'm there, my lords, can I just check that at the back of tab 44 you have a page 1026 and 1027. You should do, but it's a previous insert. But
yes.
I'm grateful.
No.
What? We'll hand up 2 of those.
There's a further tab 11, is that right? It seems already occupied by the Madeleine.
No, that's going to be the supplementary authorities bundle. Well, I'll come to that in a moment, my lord.
So this is the back of tab 44.
That back of tab, yes, back of tab 44. It's another extract from voice charters. Then again, if I can just check, you have a tab 48, which is the Apostolis.
Yep.
And then you should, in the bundle we've just handed up, we've added for tab 49 Reardon Smith.
That's Mr. Justice now on the burden of proof and unseaworthiness.
Correct.
Case argued by, conceivably, 4 of the most eminent commercial lawyers of all time.
That was going to be one of my submissions.
Apparently missed a trick, didn't they?
that was going to be one of my submissions. You should then have also, now if you can turn up the supplementary authorities bundle, which is the thinner bundle.
Yeah.
I've given you a new index for that bundle.
Right.
In tabs, you should have a tab 8, 9 and 10, which are my learned friends' extra authorities.
Yeah.
Just check you have those. And
Yeah.
there's a new tab 11, which is rows of general average. It's just 1 page.
Yeah, okay. Right.
And then you should also have on, sorry, I'll just let you do that. You should also have on your desk, and I've given one to my learned friend, I've produced a short 1.5 page roadmap for my oral submission, so it'll assist your, I hope assist your Lordship to know where I am in my submissions.
This is a roadmap or a voyage?
I hope it'll be a voyage of discovery, but it's going to be a roadmap in terms of direction.
There's a passage plan in that case, isn't it?
Indeed. It's your passage plan, is it?
It is a very much, well,
All right, Mr. Hill, we're only
I'll
teasing.
move up. I'll move on. And then you should have a table, my lords. We've put together a table, and I'll explain what this table is later when I get to it. But there are 49 authorities, of which we say the vast majority are irrelevant. The vast majority was cited by my learned friends, and I produced a table which I hope will show why none of the propositions are contested, and why.
If we're looking at Reardon Smith, Lord Donovan's remarks come to mind.
Yes, because really, and I'll come on to this in a moment, this appeal is a very narrow point, and there are a few limited cases which I've set out in my roadmap.
Yes,
that
which
are
is why we've got 3 bundles of authorities, no doubt.
Well, unfortunately, that's why we produced a table, so you don't need to look at 3 bundles of authorities. My Lord, there's one preliminary matter, which is my application to amend my grounds of appeal.
Yeah.
With your Lordship's permission, I'd like to deal with that at the end of my submissions for a number of reasons. The first is it's a short point that only applies if I lose my appeal and my learned friends lose ground 2 of their respondent's notice. So it's actually a point that is unlikely to arise, we say.
Well,
Second,
it depends, doesn't it? Because if you lose your appeal, and we hold that the judge's judgment is correct, then unless we allow you to run a point which you've never run before, you never pleaded, you've got no evidence about it, it was never, as far as I can see, and I think your solicitor accepts this, it was never raised before the judge at all. It comes to light last Wednesday.
well, I see your Lordship's early comments on that. I would hope to persuade your Lordship otherwise on every point on that, but I'd like to do so at the end of my submissions, the reason being because once I've dealt with my main grounds of appeal, and once I've dealt with my learned friend's notice of appeal, all the points actually will come out then that respond to their submissions they put in yesterday, and time is limited and I don't want to take up, I don't want to be inefficient and make the points twice.
Well,
And
we
the
haven't
points-
seen any any response from Mr. Russell's side to your 3rd ground of appeal.
Oh, it was yesterday, so maybe my learned friend can hand it in.
I'm so sorry. There was a skeleton argument and a bundle of authorities that we sent across to the court.
Well, we haven't
Yes.
seen it.
I,
We've been absolutely inundated with late papers in this case.
I know. I obviously apologise for that to the extent that
I imagine it's this document that's on the desk as we speak. We see it, but it's being put on our desks.
I can only apologise for the fact that it hasn't been sent to your clerks personally. It is an important point because we characterise the application to amend very differently from the way in which my friend characterises it. We do say, as your Lordship has said, that it's a new point that wasn't pleaded, that wasn't raised in argument before the trial judge at all. And the absence of its being argued significantly shaped the way in which the case developed at trial and was put at trial.
Well, my learned friend can put these points when I make my application.
Well,
I haven't. Well,
Well, Mr. Hill, putting it colloquially, those who live by the sword die by the sword, frankly. If you put this point in, and we haven't seen what Mr. Russell says, it's helpful for us to know, at least in summary, what Mr. Russell's case is. But are you content for it to be dealt with at the end of the appeal?
Well, Lord, not really, no. Because if it's dealt with at the end, rather than my submission would be the more normal way of dealing with it at the outset, I'm going to be in a very difficult position when I stand up to make my submission at some point this afternoon, because I don't know what the case is that I've got to meet. And we say that this is absolutely not a pure mechanical point. There are important points of substance here. And really, obviously I'm in your Lordship's hands, but the court has been put in this difficult position because the application was made on Friday, one working day before the hearing was due to start. And really, it will cause me some prejudice if, when I stand up this afternoon, I don't know what the scope of the appeal is. I'm incredibly sorry that your Lordships, that we didn't ensure that your Lordships got the skeleton argument that we put in yesterday, because obviously that would have given you more of a chance to see what we say in advance. But we've put in an argument in relation to the principles that apply when there's a late application to amend. Not only, of course, a late application to amend the appellant's notice, but a late application it also be for permission to appeal on new points, because the amendment goes nowhere unless there's also permission to appeal on these new points. And my submission, I really do need to know what the scope of the appeal that I've got to deal with is before we proceed.
My Lord,
Just a moment, Ms. Hill. Yeah. What we're going to do is we're going to rise for 5 minutes to read your skeleton argument, Mr. Russell.
I'm grateful.
And to consider whether we should hear the application to amend now.
Yes.
And I entirely take on board it is actually in the first instance an application for permission to appeal
Yes.
before we get anywhere else.
Yes.
Right. Silence, court rise.
Thank you very much, Mr. Russell. We've considered your submissions. Well, the way in which we wish to proceed is as follows. That Mr. Hill should argue the appeal on the basis that this point has not been raised at all, and you should deal with the appeal as it stood. When we have heard all the argument on the appeal, we will then consider the application if there is time. If there isn't time, hard luck, as they say. But we take on board all the points that you make without passing comment at present as to whether they're right or wrong, but at least two of them had occurred to members of the court. Right, okay, Mr. Hill.
Grateful, my lord. Can I just say on that, we do obviously disagree, my learned friend, that it wasn't raised.
Of course you do. Well, let's get on with the main appeal.
Well, let's get on with the appeal. My lords, this appeal, certainly our appeal, determines or considers a very narrow issue. And it's important to make clear the limited scope of the issues which arise on our appeal. And we'll deal with it in two stages, my lord, my introductory comments. First, I'll explain what owner's appeal is about, and then I'll explain what owner's appeal is not about, and therefore I hope demonstrate why many of Cargo's cases and much of their submissions are irrelevant. What is this about, this appeal? We say the essential question is whether the recording of the crew's navigational decision on passage planning and recording into a passage plan document before the commencement of the voyage transforms what would otherwise be an error of navigation under an exception of Article 4.2a into a matter of seaworthiness under Article 3 Rule 1. Or put it...
Just to make sure we got this down correctly, the essential question is whether the recording of the crew's navigational decisions in the passage plan
on passage planning into a passage plan document before the commencement of the voyage transforms what would otherwise be an error of navigation under the exception in Article 4 Rule 2a into a matter of seaworthiness under Article 3 Rule 1. And we put it
when you talk about recording in passage plan, you mean recording in passage plan and charts, is that
yes, right? and I'm going to come to that. Charts, underkeel clearance calculations, a whole wealth of documents. Passage plan is not just like a certificate, it's not one document.
Yeah.
And we'll put it another way, does the character of the error as an act of navigation cease to be legally relevant to whether or not the vessel was unseaworthy? Now this is important because if the error in navigation falls within the scope of Article 3 Rule 1, then of course owners can no longer rely on Article 4.2a exceptions. So stating the obvious, the wider the scope of Article 3 Rule 1, then the narrower the practical scope of Article 4.2a. This is because although an error of navigation by the crew will also be a breach of Article 3 Rule 2, the obligation to look after the cargo, owners have a time-honoured exception to that breach, but they don't have an exception to breach of Article 3 Rule 1.
Can you help us with what you mean by crew's navigational decisions
Yes.
on passage planning?
Yes, there's a wealth of decisions that will be made by the crew when planning the passage. Those decisions will be essentially navigational decisions about where to go, what hazards to avoid, where not to go, marking, for example, in this case, no-go areas. All of these decisions involve seamanship and judgment.
Those are three ways of saying the same thing, aren't they? Where to go, hazards to avoid, and where not to go.
No. So where to go would be your classic hill harmony, the route. What hazards to avoid? Do you go this side of an island or another side of an island? Finally, for example, on the third one I put, the no-go areas, the hatching of a no-go area. And I'm going to take your lordships to this when I develop my submissions. But there's a whole, there was a considerable debate over 10 pages of the judgment about what you do in this passage plan to properly represent the warning in the notice to mariners. That is an issue of judgment. It was a decision that the crew should have taken prior to commencing the voyage. It's a navigational decision. So they're the types of decisions. Basically, when you're planning your voyage, a number of navigational decisions are taken. They are then recorded in a passage plan document, lots of them, different types of documents. And we say those acts do not cease to have the legal character of acts of navigation just because they take place before the commencement of the voyage and are written down. Well, in fact, I'm just going to come to that point now.
You characterise them as acts of navigation, but they hadn't left the port.
But
this was planning, it wasn't navigation.
with respect, no. If your lordships can turn up, I was going to
The point is that I think my lord has in mind any number of cases where what would be navigation or management of the vessel, if it took place during the course of the voyage, in fact occurs before the vessel leaves the load port, and that amounts to unseaworthiness, to which there isn't a defence under 4.2a.
Correct, but again, if I can get through some of my early submissions, I think I'm going to answer all of these points that your lordships have. But just on 2 points, can I just go back on each one? My Lord Justice Haddon-Cave's point. If your lordships just turn up, we'll come on to it later, the supplementary hearing bundle, tab 2, you'll see the resolution for the guidance of voyage planning. And you'll see at page 32 of the bundle, in paragraph 1.3, that voyage planning includes 4 items: appraisal, detailed planning, execution and monitoring.
Hang on a minute, where are you?
Page 32 of the bundle, tab 2.
Page?
32 of the bundle.
Well, we've got 2 pages. We're looking at 32.
The middle number is the bundle number.
Okay.
Paragraph 1.3. Voyage planning consists of appraisal, detailed planning, execution, and then monitoring after each semicolon. And then you'll see the rest of this document. Heading 2 is appraisal, heading 3 over the page is planning, heading 4 is execution, and heading 5 is monitoring. Now, my lord, this is something I'll come to later, but execution and monitoring are obviously taking place during the actual course of the voyage when she's left the berth. They don't involve a document. The first stage, appraisal, is considering all the material. This is done before she leaves the berth. It doesn't involve a document. The only part that involves a document is the planning stage. But that is one of 4 stages. And it's one of 4 stages in the whole concept of planning, passage planning. And it's artificial to break that up. And again, I'll come to that point. Can I just deal with my Lord Justice Flo's point, which is there's a whole wealth of cases that says, well, if navigation or management results in the vessel being unseaworthy, then it's unseaworthy before the commencement of the voyage. Again, I hope to show your lordships during the course of the morning that that's not quite correct. There are a number of cases where an error in the management of the vessel affects the physical attributes of the vessel or some other attributes of the vessel, which would therefore render it unseaworthy. There is no case that either counsel has been able to find where a pure act of navigation renders the vessel unseaworthy just because it's written down in a document or just because it occurs before the commencement of a voyage.
So I'm having difficulty with your phrase, an act of navigation.
Yes.
When I'm planning to leave court at 1 minute past 1 and walk out and turn left and then right, I'm not actually walking, I'm not navigating, I'm just thinking about it and planning it. There's a difference, is there, between an act of navigation and planning something.
No, for example, we'll come on to it, the Hill Harmony. Let me take you to the Hill Harmony now, okay? I'll just jump ahead in my submissions. If one goes to the Authorities Bundle 1 and turn to tab 25, if we can start on page 657 of the authority. Again, I was going to come to this, but I'll deal with it now. It's tab 25, page 657.
657.
Taking it up from H, and actually if one just take it up at 656, it'll save me coming to it later. You'll see at D, sorry, one moment, my lord, I'm out of context here. I just wanted to put the term in context. I'll come to the point later. Let's go to 657. H. The meaning of any language is affected by its context. This is true of the words employment in the time charter and the exception of negligence in navigation of the ship in a charter party or contract of carriage, i.e. bill of lading. They reflect different aspects of the operation of the vessel. Employment embraces the economic aspect. Navigation embraces matters of seamanship. Mr. Donald Davis, in an article I have referred to, suggests the words strategy and tactics give a useful indication. What is clear is that to use the word navigation in this context, as if it includes everything which involves the vessel proceeding through the water, is both mistaken and unhelpful. As the Lord Summoner pointed out, when seamanship is in question, choices as to the speed or the steering of the vessel are matters of navigation, as will be the exercise of laying off a course on a chart. But it's erroneous to reason, as did Mr. Justice Clark, from the fact that the master must choose how much of a safety margin he should leave between his course and a hazard, or how and at what speed to proceed up a hazardous channel, to the conclusion that all questions of what route to follow are questions of navigation. Now, what I rely on there is the fact that obviously laying a course off on a chart or choosing how much safety margin to leave, these are all matters of navigation. The fact that they take place before the vessel leaves the berth doesn't mean it loses its character of being an act of navigation.
But the problem in the Hill Harmony was not that the master planned to take the wrong route, but that he actually did.
I agree, and I'm not suggesting that Hill Harmony goes any further than making the point that we make, which is navigation can take place before and after the commencement of the voyage. And you'll see this, because it's actually, again, when I get going, you'll see that this is being determined very much in US authorities. There's a US authority directly on point on that point.
But this wasn't a Hague Rules case, was it?
No, it was a charter party case, but as Lord Hobhouse says, he's dealing with contracts of carriage and the concept of navigation in the Hague Rules, because it was, although it was a charter party, it was a Hague Rules exception that was being relied upon.
But at the end of the day, the issue is whether whatever it was that did or didn't happen rendered the vessel unseaworthy.
Yes.
What label you put upon what it is that they're doing, whether you call it acting in your second ground, quae carrier or quae navigator, doesn't seem to me to make a blind bit of difference, because, and there's nothing in the Hill Harmony that suggests the contrary, because it's not a case about the Hague Rules, as my lord says.
Well, it does. It's construing the Hague Rules exceptions, but of navigation and management. So, with respect, I don't accept that.
Why isn't it? I mean, if you're right, failing to have the right charts on board the ship is an act of navigation.
But
the master decides what charts he needs.
No, it's not.
To conduct the voyages. Why isn't that as much an act of navigation as this? And there's clear authority that that's unseaworthiness.
I see your lordships have a lot of questions.
Yes.
And I understand that. I intended to do 5 minutes, 10 minutes of setting out what my case is, and I think that's going to answer a lot of your questions.
Why don't you do that?
And I'd be grateful if I could.
In other words, shut up court, I think is how you put that politely.
No, I didn't say that. What I said was I hope I will ease a lot of your concerns.
Right, well, you may or may not, Mr. Hilbert. We'll let you get on with it.
Now, my lord, we say Cargo's case is that it's irrelevant that the Act is an error of navigation for the purposes of seaworthiness, and we distill their case into 3 points. They say it's because the determination of whether a ship is unseaworthy depends on a pure application of the McFadden test. Alternatively, because the ship is unseaworthy because the error of navigation was recorded in a document, and thirdly, because it occurred before the commencement of the voyage. And those are the big three themes that are throughout my learned friend's skeleton. We say the first point is illusory, it's wrong. The McFadden test presupposes, and this is terribly important, presupposes a relevant defect with the ship. The McFadden test is concerned with whether that relevant defect in the ship is sufficiently serious to render the ship unseaworthy. Now, we ask, with what type of defect is the McFadden test concerned? Cargo say any defect that satisfies the McFadden test. See their supplementary skeleton. But that's not an answer to the question. What defect satisfies the McFadden test? Owner's answer is any defect in the ship which affects the attributes of the ship. There must be a threshold test. We are the only ones who have an answer to that question. Therefore, we say, in practice, cargo are going to be driven to making their second point, namely that it's critical that the error in navigation has been recorded in a document. This allows them to try and say that the defect is an attribute of the vessel. And we'll go on to show why that's wrong. The third point, again we'll develop later, we say cargo's case requires reintroducing the discredited and illogical distinction between acts of navigation before the commencement of the voyage and acts of navigation after the commencement of the voyage. There is no legally relevant temporal distinction. Now, owner's case has two elements, and it's reflected in the two grounds of appeal. But the two elements, my lords, are closely linked and correspond to the two elements of Article 3, Rule 1. Owners say that the actions of the ship's crew, done in their capacity as navigators, do not fall within the scope of the ship owner's duty under Article 3, Rule 1 to exercise due diligence to make the vessel seaworthy. Because they are not matters which concern the ship owner in its capacity as carrier, responsible for the state of the ship. And therefore, either they are not matters which go to seaworthiness at all for the purposes of Article 3, Rule 1, because negligent navigation cannot in of itself amount to a defect that affects the state or attributes of the ship, or two,
What about if the master was incompetent? Incompetent as regards navigation, didn't know how to navigate the ship.
absolutely, and the vessel is unseaworthy, and I'll explain
That's
why.
not that doesn't concern the ship owner as a carrier, because he might be perfectly capable of as it were, steering the ship, but he just is so incompetent he doesn't know he needs a passage plan.
No, the answer to that,
chart.
my lord, is very straightforward. The vessel is unseaworthy because she is not properly manned, and being properly manned is an attribute of the ship. And therefore, that's actually a good example that assists my case, my lord, because if she's not properly manned, the vessel is unseaworthy, but it's well established, all the owner has to do is exercise due diligence in properly employing him. And if he's done so, then there isn't a breach of Article 3, Rule 1. And that is, I'm going to come back to again in a moment, a whole case on systems, and we'll deal with that in a bit more detail. The second reason we say the same events, or same facts, there's no breach of Article 3, Rule 1, is because even if pure acts of navigation in of themselves can somehow render the vessel unseaworthy, they are not matters which fall within the scope of the ship owner's orbit of responsibility as carrier for the purposes of due diligence.
Sorry, can you repeat that submission?
Yes.
Even if pure acts of navigation render
pure acts of navigation
render the ship unseaworthy.
correct, these are not matters which fall within the scope of the ship owner's orbit of responsibility as carrier. And that the words I've chosen there are very important. Orbit of responsibility are the words that you get from a number of cases dealing with delimiting the scope of due diligence under Article 3, Rule 1. They're delimiting words.
So not within Article 3, Rule 1 at all?
My Lord, yes, essentially, yes. So, can I just expand a bit on the unseaworthiness point first?
Yep.
Owners say that a one-off defective passage plan will not render a ship unseaworthy. Now, we'll develop it again in due course, but essentially owners say that seaworthiness is only concerned with the state and attributes of the ship, such as its hull, machinery, equipment and crew. Therefore, only defects which go to the condition of the ship may render her unseaworthy. A one-off passage plan, a defective passage plan, does not go to the condition of the ship and doesn't render her unseaworthy. Instead, a one-off defective passage plan is the recording of the navigational decisions of the navigating officer and the master regarding passage planning. It's not an attribute of the vessel. Now, this is not to say, my lords, just in case you think I'm standing here trying to get owners off scot-free, this is not to say that owners do not have important obligations regarding seaworthiness and passage planning. The owner must ensure that his ship has on board everything that is required in order for the crew to properly prepare a good passage plan. That will include underlying primary materials such as charts and other nautical publications. 2, proper systems in the ship's safety management system, its SMS, requiring and instructing the crew how to prepare a passage plan. And 3, and most importantly, a competent crew. These are matters that all go to the condition of the ship, her equipment, supplies, and crew. And this is the important point. The use to which the competent crew put those materials supplied by the owner is a pure matter of seamanship and navigation. This does not go to the condition of the ship, her equipment, supplies, and crew. And this is going to be the underlying theme of most of my submissions. The fundamental distinction is then between, on the one hand, there being on board everything required for the crew to navigate safely, and then on the other hand, the actual act of navigation by the crew. An owner is responsible for the former, but he is not responsible for the latter. The latter is within the domain of the crew as navigators and falls within the fundamental exception in Article 4, Rule 2A for errors in navigation. It really is that stark. It's between an owner doing everything he reasonably can and put on board the vessel everything that he can to allow the crew to navigate safely, as compared with the crew navigating safely. And that's the answer I hazard to say is an answer to my Lord Justice Faux's point. Putting everything on board, including charts, is a matter for the carrier quay carrier. He has to equip the vessel and make sure that the crew on board can navigate safely. Whether they do so or not is out with his responsibility.
Do you accept that if a vessel leaves port without a passage plan, it is unseaworthy? Without a passage plan at all?
I say it may be unseaworthy because the crew are incompetent, but the fact that it doesn't have a written document doesn't render it unseaworthy.
Do you accept that if a vessel leaves port without the relevant chart that it needs, it's unseaworthy?
Yes, because if it doesn't have the chart, it doesn't have on board all the equipment necessary for the crew to be able to navigate safely.
Do you accept that if a vessel leaves port without the relevant chart being updated, it is unseaworthy?
that's a moot point. It doesn't arise on the facts of our case, but I would accept probably yes, because, and I'll give the analogy against myself, a ship owner can, it can be his choice, just every time there's an amendment to the chart, arrange for a new chart to be provided to the vessel. For efficiency reasons, owners choose not to do so. They have a contract with Her Majesty's Hydrographic Office, and notice to mariners are sent to the crew, and they update the chart. And therefore, to argue the case against me, I would say, yes, it's probably more within the realm of a carrier that he has to make sure the vessel has an up-to-date chart. But I don't think anything's going to turn on that on the facts of this case.
Do you accept that if the crew don't update the chart, having received a notice to mariners, that the vessel's unseaworthy?
Again, if because the crew are incompetent, yes, I do.
If the crew are competent, but just by reason of an oversight, did not update the chart, would they, by reference to a recent notice to mariner? What's your answer to that proposition?
My answer is it's a moot point, but I'm prepared for the purpose of this appeal to assume it against me, and that it is.
Sorry, assume against you.
Yes, and it
That
is.
it
But
renders
it's
the
a
ship
moot
unseaworthy.
point, and it's irrelevant in this case, and I don't want to bind other ship owners coming along behind me.
It may not be. You accept that in those circumstances, the crew failing by reason of an oversight to update a chart by reference to a recent notice to mariner, that the vessel would be unseaworthy.
That is not an act of navigation. It's a mechanical exercise of updating a chart.
So,
Well, in your case, it's a failure to carry out an act of navigation, isn't it?
No, the act of navigation. No, it's not. It's not at all.
Well,
I'll explain why. The act, the division of responsibility, and is as follows: the vessel has to have on board all of the materials and a competent crew, such that a proper passage plan can be created. Then the act of the 4 stages in the IMO guidelines of appraisal, planning, execution and monitoring are acts of navigation. And this goes to my learned friend's respondent's notice point 1, which is you can't say updating the chart with the warning at the top, warning depths can't be relied upon. That can't be an act of updating the chart and an act of passage planning, because you passage plan on updated charts. So it's either an updated chart or it's passage planning. It can't be both.
my next proposition was going to be, why does it make any difference that by reason of an oversight, the crew didn't since update or include in their passage plan a notice to mariner warning?
A huge...
Given your previous concession that a chart in those circumstances would render the ship unseaworthy, why does it make any difference that a passage plan
Because
doesn't render the ship unseaworthy?
because, my lords, every chart you buy from Her Majesty's Hydrographic Office should be identical. And therefore, it doesn't involve any issue of judgment, seamanship, which is critical to navigation. And therefore, if in fact, I'll give your lordships an example, we didn't send them the notice to mariners, we just sent them a new chart each time they left the port, and the owner sent a new chart. What you do with that chart, for the purpose of planning, appraising and planning your voyage, and then subsequently executing it, is a matter of navigation. Updating a chart is simply not an act of navigation, it's a mechanical expedient, a mechanical act which is done for expediency and cost reasons by a crew rather than being sent a new chart.
So if there is a piece of information in a notice to mariners which needs to be put on the chart, but there are 2 ways of doing it, and neither is done, then that makes all the difference.
That hypothesis can't exist, because a notice to mariners is very clear. It tells you exactly what you have to do. There can't be 2 ways of doing it. And that's the point I'm going to make on my learned friend's respondent's notice. He's just wrong to say that by writing a warning at the top of the chart, warning charted depths can't be relied upon, is an act of updating the chart. It is not. You'll see that there was 10 pages of the judge.
The judge found, didn't he, that there were two ways in which you could have put on the chart the warning that was in the notice to mariners. You could either actually write on the chart, or you could put in a hatching of unsafe areas.
Correct.
The judge found that either of those was a way of doing it. He preferred the former rather than the latter because he accepted the point about cluttering up the charts with all sorts of information.
Correct. But
that's an example of what my lord's put to you, that two ways of doing it, neither of which is done.
No, that's not updating chart. That's passage planning. That's all the point of using your skill, you're exercising skill and judgment and seamanship in planning your voyage. That's all part of passage planning. It is not updating a chart. And I'll come on to this on my
Why isn't it updating the chart? If you get a notice to mariners that says there's a shallow on the west side of the fairway coming out of Xiamen, because the latest soundings demonstrate that the depths shown on the chart are unreliable. Those on board the ship are expected to put that update on the chart, aren't they?
No, my lord. No, my lord. If your lordships take up, please, bundle. I'll make that point very clear because this is important because there's a fundamental error here. If you take up the second supplementary hearing bundle, not the authorities bundle, the hearing bundle, and turn to tab 2, for example. This is a notice to mariners 1691, which was issued.
What are we looking at?
Tab 2. It should be look like this.
Which bundle are we in?
Second supplementary hearing bundle.
Second supplementary bundle. Second supplementary bundle.
Second supplementary bundle.
Tab 2. Yeah.
Tab 2. That is a notice to mariners. It's notice to mariners 1691. It was issued a couple of weeks before the grounding, and it tells you how to update the chart. And what you do, my lords, is that this comes to you on tracing paper. You print it off on your computer on tracing paper. You lay it over your chart, and you update these soundings. That is updating your chart. And if you go back, my lords, to the previous tab, you will see that the only updates that were required in relation to the relevant notice of mariners in this case, the relevant notice of mariners was 6274p, and this is, my lords, if you turn it sideways at the top left-hand corner, 6275, and this notice of mariners tells you how to update the chart. What it says is, chart 3449 Beijing, amend, legend, C, NM 6274p. Now I'm not going to ask your lordships to take this out because your lordships will then get in a bit of a mess, and I'll do it with my version here. What happens on the chart, and it's in, if you wanted to see it, it's in the supplementary bundle at tab 4. What happens, my lords, is the chart tells you, C, notice to mariners, and the old one was 705. And what it tells you is cross out 705 and write 6274. You'll see it, it's in two places, my lord. It's on the bottom, I won't use nautical terms, it's on the bottom right hand corner. I'm pointing to it there. And there's another one you'll see in the photographic coloured box at the top, towards the top right hand corner. You'll see where they cross out 705 and put 6274. Now this is fundamentally important. That is the update to the chart. That is what was required by Her Majesty's Hydrographic Office to write on the chart. Now, so you're being told on the chart, as part of passage planning, consider that notice of mariners 6274. Now, what happened was the judge decided, as a matter of passage planning, when you are considering all the various aspects of risks, what you should do, he took the view that you could either hatch no-go areas, or you could write a warning at the top of the chart. Right up here, he was saying you could write a warning up here, warning debts not to be relied upon, or something like that. And he took the view that different experts had different views, and he took the view you write it on the chart like that. That is an act of passage planning. It is not an act of updating a chart. Now, my lords, going back to where I'd done my first...
The failure to write it on the chart meant the ship wasn't able to make a safe passage, didn't it?
The failure to write it on the chart meant they conducted their planning of the passage.
Because the judge found it was whether or not it was unseaworthy is obviously a question of law. But in terms of causation, the judge found that the failure to put a warning on the chart, either in saying none of these depths are reliable, so for goodness sake don't go outside the fairway, or hatching those areas outside the fairway, one of those should have been done. Failure to do so rendered the ship meant that it was unsafe, and he found that if the chart had been marked in one way or the other, the master would never have undertaken the course which he did, because he'd have looked at the chart and he'd said, goodness me, I better not do that, but stick to
Absolutely. I accept it was causative. I would like to appeal it, but
it is a point that goes to the safety of the ship, but it doesn't render it unseaworthy.
No, it doesn't go to the safety of the ship. My lord, consider, I was going to come to this example later, but I'll do two examples now for your ships. Okay? I accept, and I've never suggested otherwise on this side, we've never suggested otherwise, that an act of navigation can render the vessel unseaworthy because it affects the attributes of the ship. So, I'll give you an example. The master negligently navigates his vessel as he comes alongside the berth at Germain and hits the key too hard. He causes a crack in the shell plating. That act of navigation has affected the attributes of the ship. She's now got a crack. And if he leaves Germain without repairing that, inspecting and repairing that, the vessel is unseaworthy. But she's unseaworthy because she's got a crack in the side of her shell plating. The fact that it arose by reason of an error in navigation is just causational history. So I'm not saying unsafe navigation can never cause the vessel to be unsafe. It can. I'll give you another example which I was going to come to. Imagine the vessel has an absolutely perfect passage plan. It says, leave Germain we're going to leave Germain before 4 p.m. in the afternoon. And the reason you had to leave before 4 p.m. in the afternoon was because of the height of tide and, say for example, water across a bar in the entrance to the port. Let's say at 3 o'clock in the afternoon, an hour before the latest date for leaving, time for leaving, the loading of the cargo is going slowly. And the master goes, I'm not going to make 4 p.m. But you know what? I'll be fine. I'll go at 4:30. But he doesn't amend his passage plan. His old passage plan was absolutely perfect. He goes at 4:30 and then grounds. That is a pure act of navigation. It took place before the commencement of the voyage. Fine, it took place before the commencement of the voyage. That's irrelevant. And I'll show you a number of cases that show that's irrelevant. But not only did it take place before the commencement of the voyage, it doesn't matter whether he wrote it down or not, it was in his head. But it didn't render the vessel unseaworthy. Now, if he was incompetent, it would render the vessel unseaworthy. But if he was not incompetent, if this was just a one-off act by him, then that is a navigational decision. I'm going to leave at 4:30 and push it rather than leaving by 4. That he shouldn't have made. It was an error in navigation, and he would be entitled, or the owners would be entitled, to the benefit of the exemption under Article 4.2a. And the fact that it took place before the commencement of the voyage, and the fact that it wasn't written down, is irrelevant. Now,
Yeah.
I was just going to introduce the second argument, which is due diligence. Now, the essence of our case is that an owner is not responsible where the negligence by the crew in the passage planning results in a one-off defective passage plan document. As I've said, that's a pure act of navigation. And obviously, if the defect in the passage plan was caused by a lack of systems or incompetent crew, the position would be otherwise, and it is. Now, this concept of responsibility can be delimited in two ways. The first one I've already talked about, which is a passage plan is not an aspect of seaworthiness for the purposes of Article 3, Rule 1, because it doesn't go to the attribute of the vessel. But the second way in which it can be delimited is that an owner is not responsible for an absence of due diligence by the crew in preparing the passage plan. And again, that corresponds with the two ways in which we put the appeal. Now, the same reasoning applies at both stages. A carrier's responsibility is to ensure the ship has on board materials needed for navigation. If it exercises due diligence to do that, then the carrier has satisfied its obligation of due diligence under Article 3, Rule 1. If those materials are then negligently used by the crew in the exercise of seamanship in the passage planning process, then that's a matter of navigation and out with the carrier's responsibility.
What about if the crew negligently failed to close the bilges or something before they set off?
That's the classic porthole cases. If your porthole is somewhere that's very easily accessible, then the vessel is not unseaworthy if the crew, as the weather gets up, just walk over and choose to close the porthole. If your porthole is down in the holds,
I'm talking about bilges, they're down in the hold.
where you don't have ready access because they're under the cargo, so that if the weather gets up, you can't shut them, or porthole.
Well, let's talk about stopcocks then. The crew failed to close an aperture below the water properly,
Yes.
and they set sail. Why isn't the ship unseaworthy?
Again, it depends on, if you look at the authorities, it all depends on the facts. She's not unseaworthy if, in fact, there would be no reason to have that shut at that time prior to the commencement of the voyage. If, in fact, there is a reason to have it shut, then she will, prior to the commencement of the voyage, she will be unseaworthy.
Right. Let's take the Herald of Free Enterprise. She sets off from Zeebrugge with her cargo doors open. She was unseaworthy.
She was unseaworthy. And that goes to the physical attributes of the vessel, and therefore it's within the realm of we're looking at due diligence, it's within the realm of the carrier's orbit of responsibility.
So in your case, it has to be a physical attribute of the vessel.
Not purely physical, and I'm going to come to that. I just used the word there physical because the example was the physical opening of the doors. I don't put my case so high that it always has to be physical, and if in 2 minutes I am going to come to some substantial submissions on that. Can I just finish one point on due diligence, introduction to due diligence? So our primary case is that the due diligence analysis is actually a simple cross-check to show why owner's case on seaworthiness is correct. But we do say there is a residual important case in any event. Even if a one-off defective passage plan can render a ship unseaworthy, the owner's obligation to exercise due diligence is limited to ensuring that the ship has on board all of the materials needed for navigation. The negligence by the crew in preparing the defective passage plan and rendering the ship unseaworthy is not something within the ship owner's orbit of responsibility, and that's the word that comes out, the words that come out of all the cases when you look at due diligence.
Why isn't it the case if it is unseaworthy? Why isn't it part of the non-delegable duty?
Because it's not within the ship or the carrier's orbit of responsibility.
Well, the carrier's orbit of responsibility surely includes that his vessel is safe to leave port. And if his crew failed, if through negligence his crew failed to have on board a proper passage plan, so the ship isn't safe to leave port, if that's unseaworthiness, and I appreciate your primary case is that it isn't, but if it is unseaworthiness, why isn't that part and parcel of the non-delegable duty under the Muncaster Castle?
Because it's not within the orbit of responsibility, and the classic example is the Captain Sarakov. There was a on-deck container full of dangerous cargo that the ship owner did not know about.
Well, the point about the Captain Sakharov was that that was all to do with who's been responsible for stuffing the containers.
No. With respect, it's a bit more nuanced than that. What it is
I do remember the case. It's fair to say it's a long time ago. But
yeah. What? I thought you might. What that was about is, firstly, on stage one, the vessel was unseaworthy because whether or not the owners knew about it, there was a container on deck which had dangerous cargo that shouldn't have been there. Okay? So she was unseaworthy. So that's firstly. But on the facts of that case, it was not within the orbit of responsibility of the carrier.
you better look at the case if you're going to make submissions about orbit
Well,
responsibility.
can I park it and do it later?
If you wish to, yes.
I will do because I've given you the answer to why I say it doesn't apply. And just as stuffing containers is not within the orbit of the responsibility of the carrier, nor is navigation. It's not within the orbit of a carrier. Now, my lords, I've handed. I'm conscious of the time. I was going to go through the table I'd handed up, which is what this case is not about, and what propositions of law my learned friend cites all his cases for, and why we don't dispute them. But I'm not going to do that now because, to be honest, I'd rather get on with my own submissions rather than respond to all the cases he's put forward. Now, so if you take my roadmap, my lord. I'm going to deal with item 2, which is 2 foundational principles in relation to seaworthiness. And the first one is seaworthiness concerns the attributes of a ship, and that is absolutely crucial to our appeal. Now, as I said, seaworthiness concerns the attributes of a ship, and therefore the obligation on the owners under Article 3, Rule 1 is directed to the attributes of the ship. I'll say that again because that's quite important. The obligation on the owners under Article 3, Rule 1 is directed to the attributes of the ship because he's got to make us seaworthy, and the seaworthiness concerns the attributes of the ship. This, my lords, delimits the scope of Article 3, Rule 1 relative to the owner's other obligations, such as under Article 3, Rule 2, which permits for exceptions. So, the wider the scope of Article 3, Rule 1 means the narrower the practical scope of the Article 4, Rule 2 exceptions, and that's obviously because you cannot rely on an Article 4, Rule 2 exception. So, my first concept is policy. This delimitation is an important aspect of Article 3, Rule 1, because Article 3, Rule 1 is an overriding obligation not subject to any exceptions. The obligation is very onerous given its non-delegable nature, such as, for example, with physical defects, the only practical excuse is it's a latent defect. Now, there was a bargain struck, my lords, at the 1921 Hague Conference, and it was aptly summarised in the preparatory materials in the Travaux, but I'm going to show you where it arises in a case called the Tasman Pioneer from the Supreme Court in New Zealand. If you lordships can take up the authorities, second authorities bundle, and turn to tab 30.
Sorry, second authority.
Yes, it's second authorities bundle, tab 30. And the Supreme Court of New Zealand, and this was concerning Article 4, Rule 2A, negligent navigation. And what I want your lordships to do is read 2 passages. The first one starts at page 17 of the report. And could your lordships read paragraph 25, which goes over the page? And if, for your Lordship's notes, if you want to see that quote from Sir Norman Hill in context, you'll see it in tab 42, which is the Travaux. If you Lordships can then read paragraph 8, going backwards in the report at page 15. Therefore, my lords, the ship owner interests at the conference accepted cargo's interests obligations on the ship with regard to seaworthiness. That was Article 3, Rule 1. The quid pro quo was that ship owners' interests required their exceptions to the obligation to carefully carry cargo, the most important of which was negligent navigation. And this is the commercial fault versus nautical fault division.
Indeed, and in line 8 of paragraph 8 refers expressly to acts or omissions of the master and crew during the voyage.
Yeah.
Brackets, nautical fault.
That's loose language. I'm going to show your lordship a number of cases where that is clear that that is not correct. But since...
Sorry, what's not correct, Mr. Hill?
The word, well, it's just loose language during the voyage, just you see before the definition of nautical fault.
Why is it loose language?
It's loose language because on the facts of that case it didn't matter, because it was
The Article 3, Rule 1 says the carrier should be bound before and at the beginning of the voyage, etc., etc. And so this paragraph is simply drawing this distinction, as it says, matters within their direct control, such as the seaworthiness and manning of the vessel at the commencement of the voyage, contrasted with acts or omissions of the master and crew during the voyage. I thought that's very clear language.
No, my lord. I'm going to come on to this later on another submission. But the distinction, that was, and that's why I took you to Sir Norman Hill's point first. The distinction is not a temporal distinction. It's not between before the commencement of the voyage and after the commencement of the voyage. And I'll show you a number of authorities that make that absolutely clear. The distinction is between a nautical fault, which from time immemorial has always been an exception, and commercial fault, which is essentially the state of the vessel. That's the delimitation.
Speaking for myself, my Lord's point is really a very simple one, isn't it? That under Article 3.1, which you've helpfully appended to your skeleton, the Hague Rules say expressly the test is seaworthiness act before and at the beginning of the voyage.
Correct, my lord.
So how do you get past that
Very easily.
fundamental issue?
Very easily, my lord, because what has to be before and at and before the commencement of the voyage, it has to be seaworthy. And that goes back to my first foundational principle, which is what is seaworthiness? It has to be a defect in the attribute of the vessel. If there is nothing wrong with this vessel, she is not unseaworthy. And therefore, the issue is then whether or not a pure act of navigation can render a vessel unseaworthy, because it's an attribute of the vessel, and it's not.
Isn't that circular with the recital?
It is a circular argument in a sense. I mean, I understand the argument, Mr. Hill, but it is in a sense a circular argument, because if having the right charts on board is part of the attributes of the vessel, it might be said having a proper passage plan or a non-defective passage plan is also part of the attributes of the vessel.
No, it's not, because that is an act of navigation. It's passage planning, which is an act of navigation.
Well, we're going round in circles, really. We've got your submission.
Well,
this is all navigation. What would help us, I think, is if there are any other authorities who
I'm going to-
care on the specific issue, which is whether something which you can characterise as navigation, but which occurs before or at the commencement of the voyage, does not fall within Article 3, Rule 1.
And I'm
It
going to
falls
do
within
all of that,
42A.
my lord, in this section 2. And I will
jolly
answer all your, I hope, all your concerns.
Right, jolly good.
If we go to, just before we go on to that, my lord, yes, I've already made that point. My lord, authority. Cargo interests position is that any defect of whatsoever kind is capable of amounting to unseaworthiness, so long as it satisfies the McFadden test. But that's not right, we say, as a matter of law. One does not even get to the McFadden test unless the relevant defect is one which is an attribute of the ship and capable of amounting to unseaworthiness. Now, my lord, if you can start with voyage charters, it's in Authorities Bundle, second bundle, tab 44. And it's paragraph 85.95, which is the first page. Um, 85, spot 95. The subparagraphs A, B, C all concern aspects of seaworthiness, and as discussed above, the vessel is required to have the degree of fitness that an ordinary prudent ship owner, judged by the standards prevailing at the material time and having regard to the probable circumstances of the voyage in prospect. If the owner had known of the defects, would he have required it to be made good before the voyage began? So that's the test, the McFadden test. Then if you go to the end of that paragraph, however, there must be something about the state of the vessel, her crew or equipment, so that the mere performance of a function, which is not intrinsic to the vessel, but which may pose an empirical risk, does not amount to unseaworthiness. So, again, that goes to my lord's point. It is something that is about the state of the vessel. The passage plan is not about the state of the vessel.
Why not?
The passage plan is not about the state of the vessel because it is a document. Well, firstly,
It's ready to go to sea, and it's not simply going for a little turn around the bay. It's going a long way
it's going to Hong Kong.
far east.
It's going to Hong Kong, and on the way to Hong Kong, certain things have to be done during the voyage, and they have planned that voyage. And what they have done,
They've planned the voyage. They've got enough fuel on board. They've got enough crew. They've got enough food and water.
these are states. These are physical conditions of the vessel. These are the states of the vessel. Okay, so I accept, and I'll come on to it later. You have to have sufficient bunkers, okay, because that goes to the attribute of the vessel. The point about the passage plan, and you'll remember the 4-stage example I give in my supplementary skeleton, the fact whether or not you've written it down is frankly irrelevant. It's irrelevant whether or not that passage plan was written down in a document. And if my learned friend is going to say that, well, I think he's going to be driven to say that's the crucial element. But if I'm right that it doesn't need to be written in a document, what is there that is wrong with the ship?
Sorry, you misunderstand. The phrase "the state of the vessel" surely must be seen in context. It's ready to go to sea
Yes,
in the contemplated voyage.
yes.
Why
I accept
is
that.
the passage plan part of that matrix?
Because the passage plan, now we're looking at, well, can I divide, again, I'll come to it, but passage planning versus passage plan. Can we talk about passage planning first, and then we'll decide whether it makes a difference that you've written it down or not into a document. Passage planning is not an attribute of the vessel, because passage planning is something that the crew do as part of their role as navigators to navigate. It is, sorry.
Looking at it from a different angle, planning how much fuel you need, you may say, is not an attribute of the vessel. But if the crew fail to put enough fuel, so she runs out, you'd accept that she's unseaworthy because she sets off without enough fuel.
Yes, the if she goes across the Pacific and she doesn't have enough fuel to make it across to Japan, The state of the vessel is defective. She doesn't have enough fuel.
Why is it any different?
There's a big conceptual difference because
Well, it seems to me this is a critical point here, because what my Lord's putting to you is that at the moment when the vessel leaves the load port, which is the critical moment, the crew have decided to put, let's say, I don't know, 1,500 tons of fuel on board. Physically, the vessel, there's nothing wrong with the ship at that precise moment. There is nothing about the physical attributes of the ship which is in any sense defective. But the ship is unseaworthy because she is setting out on a voyage to go to Hong Kong, and she hasn't got enough fuel on board. So at some point she's going to run out of fuel. Why is that any different from having on board the ship a defective passage plan? So when you actually leave the port, there's nothing wrong with the ship, because as we know from the facts of this case, she follows the passage plan as far as about buoy 15. Up to that point, there's nothing wrong with it. But after then, she becomes unsafe.
the answer is given by Mr. Young at the top of paragraph 8595. She's got to be seaworthy, having regard to the probable circumstances of the voyage in prospect. So, your lordship's example of not enough fuel.
No, that is the voyage in prospect.
Point.
Well, no. With respect, it's not, because it has to be again an attribute of the vessel, and that's why I took you to the end of that paragraph. A passage plan is not an attribute of the vessel. A passage plan is again passage planning is part of navigation. It does not mean that this vessel is any less seaworthy to perform the voyage. She, in all respects, she is seaworthy. What's happened is the master has when undertaking planning for the passage, made a mistake. That mistake is an error in navigation. It doesn't affect the attributes of the vessel.
Just to be clear of your proposition, you're saying a passage plan is not an attribute of the vessel.
I'm saying passage planning is not an attribute of the vessel, and the recording it in a document called a passage plan is not an attribute of the
Could I
vessel.
ask you whether you accept that a passage plan is an attribute
No,
of the
it's
vessel?
not. I do not accept that, because that is merely recording the navigational decision in a document, and for all the reasons we gave in our supplementary skeleton, the four-stage analysis, it makes no difference at all. Can I ask your lordship just to very briefly look at the apostolis and the aquicharm, because they explain what is written here. We'll start with the apostolis, which you'll see at tab 48 of the same bundle. And my lords, the facts are, it's a fire case, and you'll see the facts at the top of page 250.
250.
250. The first paragraph of Mr. Justice Phillips' judgment. And it was said that, certainly by the judge below, that sparks from welding on deck were raining down into a cargo hold.
Yeah.
And I just want to take you to two short points in the judgment. Firstly, page 257 in the judgment of Lord Justice Phillips. And 257.
257. Thank you.
Under the heading Law, Article 3, Rule 1. The judge was urged to find the cargo was damaged by unseaworthiness on two alternative bases. The first, it was argued that once the cargo caught fire, the fact of the burning cargo rendered the holds 4 and 5 unfit for the preservation of the cargo in the holds, and thus unseaworthy. The judge rejected that contention, and I think he was right to do so. For a ship to be unseaworthy, or more strictly uncargo-worthy, there must be some attribute of the ship itself which threatens the safety of the cargo. If a hold is dirty, that is properly considered to be an attribute of the ship, etc. And then
It depends on what one means by attribute.
It does. I accept that.
You have many attributes, Mr. Hill. You have a gown and a very nice wig. And
I'm grateful.
But you also have a particular type of mind or a particular personality. That's in common parlance, you say those were your attributes. It's not limited to physical attributes.
And that is why I said in answer to an earlier question, I don't limit it to physical matters. For example, I'm going to go on to explain it's got to be systems and things like that. And and I will explain that in a moment. Can we just look at Mr. Lord Justice Leggett? So just before I do so, yes, I should just point out the other way in which the alternative seaworthiness claim is put. You'll see with 257 right-hand column the alternative way between the two hole punches. They argued that the ship was in a condition that exposed the cargo to danger, having regard to the fact that there were sparks flying around. And then just by the black stripe by the side of the page. But quite apart from this, I consider that this test was fallacious. A ship will be unseaworthy if she is not in a state as will preserve the cargo from the risk of damage from the necessary instance of a ship's existence, whether at sea or in harbour. But a ship will not be unseaworthy simply because she or her cargo will be endangered if an act or activity occurs on board which is not necessary to perform while she is in that condition, and which reasonable care requires should not be performed while she is in that condition. And that's what's said there. I should take you to just a short point in Lord Justice Leggett's speech at page 244 and 245. 244, right-hand column towards the bottom of the page. To show a breach of Article 3, Rule 1, AMJ must show that the carriers failed to make the ship seaworthy and that their loss or damage was caused by the breach, or in other words, that the fire was caused by unseaworthiness. AMJ have to contend that the unseaworthiness consisted in the exposure of the cargo to the risk of fire from a spark entering the hold. But even if that were correct, it was not the unseaworthiness which caused the fire, but the fire which rendered her unseaworthy. Then over the page. The welding was not done directly above an open or partly open hold, and may have occupied no more than a short time. The judge's conclusion that the carrier was carrying out welding work above the hold, which resulted in sparks raining into it, was therefore ill-judged hyperbole. Nothing about the state of the ship rendered her unseaworthy. The owners were not in breach of Article 3 or 1 merely because welding exposed the cargo to an empirical risk of ignition. The holds themselves were not intrinsically unsafe. Now, that's the authority that Boyce Charter starts their proposition. One also should look at the Aqua Charter, which is perhaps, can I suggest, an even better authority for the proposition, which you'll see in the other authorities bundle at in authorities bundle number 1 at tab 17. My lords, the Aqua Charm is another Court of Appeal authority. The vessel was overloaded for a voyage through the Panama Canal. It was a charter party case. She loads cargo at Baltimore for discharge in Japan via the Panama Canal. The ship was overdrafted on arrival at the entrance to the canal, and she had to lighter onto another ship and then transship that cargo again once through the canal. The charterer deducted hire in respect of the period of delay. The owner claimed the unpaid hire. The owner sought to rely on the Hague Rules exceptions for errors in management or navigation in order to excuse the master's failure to comply with the charterer's orders. And in response, the charterers argued that the owner could not rely on the exception because there was a causative breach of Article 3, Rule 1, the ship being unseaworthy by reason of her draft and having to lighten. And if one just sees how it was dealt with by the judges, the first is Lord Denning, at pages 122 to 123. Can I ask you to read from 122, starting, you can maybe start at G and go over to the page at the end of A. Then if one goes to Lord Justice Griffiths, which one sees at page 125, and if I can ask you to read between E and G.
Going back to Lord Denning, I mean, the reason why Lord Denning appears to have thought this wasn't unseaworthy, so we can fully understand it, is because it didn't affect the safety of the vessel
Well,
or the cargo, because it simply meant that she spent more time on the voyage,
well,
because she had to lighten to get into the canal.
well, it goes to the attribute. There was nothing wrong with the vessel. The fact that you had to lighten to choose to go through the Panama Canal rather than round the Cape of Hope meant fine. There was nothing wrong with the vessel, intrinsically wrong with the attributes of the vessel to perform a voyage or the voyage. Perhaps
The facts of this case wouldn't necessarily satisfy the McFadden test, would they? Because
that's my next point.
the owner who knows about the overloading will say, or may say, well, that's perfectly all right. It's not going to affect the safety of the ship or cargo. We can just lighten when we get to Panama.
That's my very next point, because what I actually said, my lord, what I've got written here is actually one can, in theory, apply the McFadden test to the facts of this case and get, therefore, the wrong answer, because a reasonably prudent owner would say, okay, I've got to go through the Panama Canal. If I had known about that defect of the overloading prior to the commencement of the voyage, would a reasonably prudent owner let her go to sea? No, he would say, well, it's cheaper, I'll take the cargo out here rather than her go through the Panama Canal.
Well, it might not be.
That expense and delay.
It might not be. There might be enormous pressure on berths at the load port or something like that.
Yeah.
Well, now, with great respect, my lord, you're putting in new facts to the case. The reality is applying the facts that we know on.
No, because the owner who's where the safety of the ship or the cargo is compromised, the owner simply won't allow her to go to sea. But if it can be dealt with in some other way, then the existence or otherwise of those other facts may have a bearing on his decision.
Well, what we would
And
say...
it all depends on the facts, because if you look at the facts of if you look at the case of the Aquacharm, where the vessel leaves the load port overloading with coal, if in fact that overloading led to the ship capsizing, then she'd be unseaworthy. So it all depends on the facts. And the reason why this wasn't unseaworthiness, it's classic example of the management of the ship, isn't it?
That's my point, because if she was overloaded such that she was unstable, that goes to the attributes of the vessel and she would be unseaworthy. Here, it didn't go to the attributes of the vessel. And I do say you can apply the McFadden test.
It does.
The wrong answer.
I think the reason why we're taxing you, I suspect, is because these are cases which talk about, if you like, about the attributes of the vessel, but they don't answer the question: what are the attributes of the vessel in any given case?
Well, I agree to one extent, my lord. They don't decide every other case.
No.
What they do is give you a good guidance as to what is an attribute of the vessel. It's to do, and it's back to how Voice Charters puts it. It's got something to do with the vessel herself, her equipment, her crew, and the like. It's to do with that.
Does your case boil down really to one point, that this is navigation? This is about navigation, full stop. And you add, and there's no temporal issue. That's your case.
My case is in a sense, yes, threefold. One is the McFadden test is there's a prior question. what is the defect and does it affect the attribute of the vessel? My second point is the recording point, which is it doesn't matter that it doesn't become an attribute if it's navigation. It doesn't become an attribute of the vessel because it's recorded. And my third point is a temporal point, which is it doesn't matter whether it's before or after the commencement of the voyage. In this sense, that it doesn't become an attribute of the vessel because it's before the commencement of the voyage, if it wouldn't be otherwise.
But your first 2 points are really the same point, aren't they? It's about navigation.
It's about navigation, but there is it's very hard when one reads my learned friend's skeleton argument to narrow down whether he's really pinning it on it being a document in existence and it's been recorded or not. Because we say it makes no difference. It is an act of navigation, but if it is because it's not within the sphere of or responsibility of the owner to navigate the vessel. He has to put on board all the equipment and available material and employ a competent crew to navigate safely. If they choose not to navigate safely, he will be in breach of Article 3, Rule 2, because he hasn't carefully carried the cargo and he's liable for his servants or agents, but he will have the benefit of the Article 4, Rule 2A exception. And what you mustn't do, we say, is widen the scope of seaworthiness under Article 3.1 to deprive a ship owner of its well-established nautical exception, which has been around from time immemorial. And that's the effect of what His Lordship, the Judge, Mr. Justice Teare's judgment does. It massively expands the scope of seaworthiness and detracts and retracts the scope of the exceptions clause.
Why does it make any difference if the owners put on board equipment so the crew can batten down the hatches, and often there's padding and all this other. The crew omit to batten down a particular hatch, and she's lost in a storm by perils of the sea. She's clearly unseaworthy when she leaves.
Because she's not in a physically fit state to proceed.
So it's the physical act. As you said earlier, didn't you, that you weren't really making a stand on physical.
She's not in a state to proceed. On the facts you've given me, my lord, it's physical.
Well, that's what begs the question, isn't it? Because if it isn't limited to physical attributes, then it might be said against you, and no doubt will be said against you, that one of the attributes of the vessel is that she has on board a proper safe passage plan for the voyage that she is to undertake.
Well, my lords,
The fact that the planning that goes into it can be categorised as navigation seems to me to be neither here nor there, because it's well established that the 4.2a exception doesn't apply if what's going on goes to the seaworthiness of the vessel. And all those cases about, my lord's example, battening down the hatches might be thought to be part of the management or navigation of the ship.
it's not part of the navigation, it's part of the
Well,
management.
it's part of the management.
And I'm going to come to
The
that.
4.2a exception is navigation and management, though, isn't it?
Correct. And I'm going to come to that. My learned friends...
Just
Sorry.
proceed a little bit, my lord said. The state of the ship, if the ship leaves without sufficient fuel and runs out in the middle of the Atlantic, she's unseaworthy, isn't she?
Absolutely, because on departure she is not in a fit state to perform the voyage.
If she has a passage plan prepared before she leaves, which has this hidden defect in it, why is that any different in principle?
It's because the sphere of responsibility of the owner under Article 3, Rule 1 is to make the ship seaworthy. Therefore, you have to ask the prior question, is it an attribute of the ship? And let's say he hadn't written it down. Let's say it isn't written down, it's just in his head. Nobody would say that vessel was, if the mast was competent, nobody would say that vessel was not fit to proceed to sea.
Do you accept
Does it matter that it was written down? And I'll come on to that.
Of course
You
it
see,
matters.
that's an evidential point with respect, because if you could, as it were, cross-examine the master at that point about what his intentions were for the passage of the passage of the vessel during the course of the voyage, and he told you what they were, and that was unsafe, you might be said that's as much an attribute of the ship as if he's written it down.
Well, that's
Evidentially, of course, it's very. I mean, the reality is that passage plans are written down in one way or another, as this case demonstrates.
What?
Because ship masters don't go around, or navigating officers don't go around carrying all this in their heads. If they did, they'd be found to be incompetent.
Because they have to prepare a passage plan for the officers on the watch.
correct.
And so, I mean, that, as my lord said, is the base plate on which these submissions should surely be made. That these things are written down.
Right.
Because it's clearly required and necessary for any safe passage.
Right. Firstly, writing it. Let's take my Lord Justice Flo's example. If you could cross-examine, if it was in his head, and you had not written it down, but he had in his head decided he was going to conduct the voyage, he planned it in his head and he decided I'm going to go this way, and it turns out that was not a safe way to go. It was an error in navigation. That is not an attribute of the vessel. It is an error of navigation by the master, which, as long as he was competent, not incompetent, if it was a one-off error, it is simply an error in navigation. And you would not say it is an attribute of the ship and there's something wrong with the ship. The ship is fine. Actually, the master is fine.
I'm sorry, speaking for myself, I'm finding this whole slightly existential argument you're portraying. The reality is that passage plans are prepared in detail
In writing.
for
Yeah.
long voyages, because you've got 4 watches, 4 on,
4 on, 4 off.
So in the middle of the night, the officer of the watch can look at the passage plan and satisfy him or herself that they're on the right track, and bang, they hit a rock.
Now, if he does that, if he hits that
They
rock,
hit a rock. Just pause it. They hit a rock because prior to leaving, on board, the state of the vessel included a passage plan, a document which was going to be relied on throughout the voyage, which had a hidden defect.
right, can I deal with that exact example? I'm going to contrast two different scenarios. He hits the rock in the middle of the night because he made a one-off error in looking at the passage plan and Can I just finish?
No.
Misread the
Sorry
chart.
to press you on this.
I'm going to do the next.
Well, you're postulating something that isn't.
No, I'm not.
You're just shifting the ground.
I'm
in
not
respect.
going to, because I'm
What
going
my
to.
lord's putting to you is not that there's an error by the navigating officer, but that he does exactly what the passage plan tells him to do to the letter.
Right.
He just follows the passage plan, but the vessel hits a rock.
Can
so
I-
you
can
can't
I-
blame the
First
navigating
mate.
officer.
Can I please make this point?
First mate prepared some time ago.
Can I please make this point? If he just did it because he misread the passage plan, nobody in this room would suggest that's not an error of navigation. Why does it matter? Now I go on to your point, my lord. Why does it matter that the error in navigation is not misreading the chart when you're on the high seas, it's misreading the chart when you are planning it as the second officer, and you take the vessel over a bit of ground, a bit of area of sea that you shouldn't go over. They are both acts of navigation. They should both be excused under Article 4.
No, because
Right.
with respect, it's the same point, isn't it? As if you leave port, if you leave port with the bow doors open to take herald of free enterprise, then clearly that's unseaworthiness. If during the course of the voyage you open the bow doors because for some reason you need to, the classic example is perhaps not opening the bow doors but opening the holds to ventilate the cargo. If you open the holds during the course of the voyage to ventilate the cargo, and water gets in, the ship sinks, that's an error in the navigation and management of the vessel. It's probably management rather than navigation. But if you leave the load port with the holds open and the ship sinks, the vessel's unseaworthy. But it's the same act of navigational management in each case.
Well, in the example your lordship's just given me, it's got to be an error in the management of the ship, not in the management of the cargo. If for some reason you do something after you leave, I accept. that would be an error in management. If what you do before you leave affects the physical attributes or the state of the vessel, then that will render her unseaworthy. My simple point is, there is no logical distinction between misreading the chart on the high seas and making an error of navigation and planning your course line and putting it over something whilst you're alongside. It's still an act of navigation.
That's why I'm having difficulty. You refer regularly to an act of navigation, but the first mate sitting in port a week beforehand, or maybe sitting in the offices of the owners alongside wherever he is, planning the voyage, and drawing it out with his parallel rulers. He's not navigating. He's tied up in port. So the act of navigation, a phrase you use, is surely inapposite to describe that situation. And the state of the other point is the state of the ship, which you again refer to, must surely encompass all its attributes to be able to perform the voyage safely. And on this hypothesis, with this hidden danger, whether it's a hatch which hasn't been battened down or there's not enough fuel, whatever it is, they're all to be tested surely at the moment, as Article 3.1 says, at the beginning of the voyage.
In answer to your first point, which is the act of navigation, the concern about that phraseology, an act of navigation, and I take you back to, and it's probably worth looking at it again, the Hill Harmony makes it clear that your planning alongside is an act of navigation.
Right, let's see the Hill Harmony.
If one turns to tab 25 of the bundle 1 of the authorities, it's tab 25, page 657. We looked at it first off, and it's worth looking at it again now. It's 657H over the page to the end of that paragraph, B, around B. Can I just ask your Lordships to read that again? And then, having read that, can you go back and read on page 657, E to F, that paragraph? I'm sorry, 657. With respect, what my Lord Justice Haddon-Cave has just put to me is going back to changing the character of the decision, based on where it is made. It's, with the greatest of respect, it falls foul of that edict.
But none of this, as my Lord Justice Mayles pointed out to you earlier, there's nothing in the Hill Harmony which helps us here, because it's not a case about unseaworthiness. Lord Hophouse, who knew as much about this area of the law as anybody, would have been immediately saying to you, well, hang on a moment, this doesn't help me in whether or not something that is true it is amounts to an act of management or navigation, as opposed to employment, which is what he was actually addressing, but nonetheless, because it's something that takes place before and at the beginning of the voyage, is actually something which renders the ship unseaworthy.
Now we've got to unpack that statement with respect, because you've jumped over a critical stage with respect, I'd say. I agree with you, it's an act of navigation, and not management, and I agree with you that the exercise of laying off a course on a chart, or deciding what safety margin you should have, or the like, these are all, firstly, before you leave port, and secondly, they're all part and parcel of the act of navigation. Okay? So, and that is absolutely, as it were, square on with what the House of Lords was deciding in that case. Now, going back to the point, which is with respect, Mr. Lord Justice Faux jumped over one crucial matter. it still has its character being an act of navigation wherever the decision was taken at whatever time, and therefore it's still an act of navigation when you're alongside the port on the 17th of May 2011 when this second officer wrote his passage plan. It still has the legal character of an act of navigation. Where the job of the critical stage is does that legal character of it being an act of navigation cease to have any legal relevance now because it happens before the voyage, and can it make the vessel unseaworthy? The answer is no.
Well, that's the question that Lord Hobhouse isn't addressing, is it?
I accept he doesn't address that stage. I accept that, my lord. And if he did, we wouldn't be here because we'd have a House of Lords authority at the point. It's that stage that is the crucial stage. Does it lose its legal character of being an act of navigation because it happens before the voyage started? No. Did it render the vessel unseaworthy? No, because it doesn't go to an attribute of the ship. It is, and I go back to my original submissions, you have to see this case, we suggest you should see this case as the responsibility of the carrier under Article 3.1 is to put on board the vessel everything that it needs to be able to navigate safely. Charts, instructions, SMS.
You made that point many times before.
That's the point. Well, that's the answer to, with respect, my lord, that's the answer to the point being given to me by the bench. That's the answer. It's not within the sphere of responsibility of the carrier. It is an act of navigation by the crew.
Right. Okay, well, we've gone round that point quite a lot, Mr. Hill, so
My
I
lord.
think we've probably got the point.
I'm grateful, my lord. I was just going to deal with one point of my learned friend's skeleton argument on this issue, which I can just say very briefly given the time. My learned friends say, well, an act of navigation doesn't have to be, unseaworthiness doesn't have to be an attribute. He gives the example of systems. But
Example of what?
systems. So, for example, there are many cases where a vessel is held to be unseaworthy because she doesn't have proper systems on board. And he says, well, that's not physical, that's not whatever. That isn't an attribute of the vessel, but that's wrong. Systems, whether they are formal systems or actually de facto systems, are part of the attributes of the ship. Formal systems are contained in the SMS, which is a permanent feature of the operation of the vessel, and which applies when each new master comes on board for his tour of duty. And the systems go part and parcel with the way in which the vessel is operated. It goes to the unit, and I didn't.
Well, it makes good the point, though, doesn't it? That it doesn't have to be part of the physical attributes of the vessel. And the system is not part of the physical attributes of the vessel, but it's still part of the attributes of the vessel.
I agree, and I was going to take your
That's
lordship.
Mr. Russell's real point, I think.
I agree with you on that. It does. I accept that the formal systems and actually the de facto systems on board a vessel are part of the attributes of the vessel. And I accept that, and it goes to, and I don't think I took your lordships to it, but it may be worth just having a look at it now. Go back to the Aquicharm and see what Lord Justice Shaw says. It's in tab 17 of the Authorities Bundle, the one you've got open in front of you. Page 120. Page 126. We didn't finish by looking at Lord Justice Shaw. Bottom of the page at H. While these submissions appear superficially tenable, they cannot survive critical examination. Seaworthiness connotes an inherent quality with which the unit, comprising the vessel, the cargo, and the cargo is invested. So long as that unit maintains a constant character, passage plans change all the time. Every time you leave a port, you have a new passage plan. As long as it maintains a constant character, that quality remains inherent in it. External factors cannot influence or affect the innate attribute of seaworthiness. And that's the point with systems. The systems are an attribute of the vessel. They go with the vessel. They've been put on board by the ship owner as part of his SMS, and every master is expected to follow them. A one-off defective passage plan is not part of that unit. It's not part of the attributes of the vessel. Can I move on? Because I think some can I move on to the second foundational principle? Because this is quite important. And you're going to see a case which is on all fours with our case, although it's a US case. I'm now dealing with our second fundamental principle is that acts of navigation have seamanship as their critical element and have the same character regardless of whether they take place before or after the voyage. Now, what I want to just show you some authority on this. Can you start with voyage charters, and you'll see that in the second authorities bundle at tab. Oh, actually, I do apologise. It's gone in, I think, in the supplementary authorities bundle, the small thin one. And you'll see it at tab 5. And if you could read, we'll just have a look at some of these.
Hang on a moment. Voyage charters.
Voyage charters. I'm going to look at the first one, 85269.
Yeah.
Navigation in the present rule refers to seafaring aspects of navigation and not to the commercial, economical, legal aspects. That's the point made in the Tasman Pioneer. Seamanship is the critical element and suggests that navigation involves everything which involves the vessel proceeding through the water is mistaken and unhelpful. Then paragraph 85270. The dividing line between errors which are sufficiently relate to navigation to afford the protection of the rule, that's Rule 2A, 4.2a, and those which are connected with commercial aspects of the ship operation, i.e. seaworthiness, is not always easy to draw. It was once thought clear that there was at least a straightforward temporal dividing line, thus an error in determining what course the vessel should follow, which was made before the commencement of the voyage, was automatically outside the exception. And likewise, although the whole period up to the conclusion of the voyage and making fast alongside was included, it did not extend to beyond that point. In SS Lord, it was held that negligence in the navigation of the steamer was concerned only with the time when the ship was in motion and being navigated. That's the point my Lord's just made. This analysis in terms of a simple temporal dividing line has been held by the House of Lords in the Hill Harmony to be wrong, or at least too broadly or confusingly stated, for the character of a decision about the sailing of a ship is not determined or altered by the time the decision is taken. And he then goes on, 272, if one looks at 272, 8527, perhaps one can say no more than the relevant error must be sufficiently related to truly seafaring aspects of the conduct of the voyage. And that's why we say, obviously, passage planning is solely related to the seafaring aspects of the conduct of the voyage. Now, if one then turns over the tab, you get Tetley on marine cargo claims. Page 956, you'll see first main paragraph. This is dealing with the Article 4.2a exception. In consequence, it would appear that an error of navigation of the ship is some mistake or negligence as to a matter of seamanship, which comprises the safety of the vessel and its crew, resulting in cargo loss or damage. Then over the page, bottom paragraph, error in the navigation or management of the ship may occur before the commencement of the voyage as well as afterwards. And if you see footnote 16, it refers to, the last case it refers to is the Eusiminas case in Scandia steamship navigation, which is actually a very interesting case because it's completely on all fours with this case. And we've got it for you at tab 7. Now, and it's worth going through this case and seeing the parallels with our case and seeing the conclusion that the appeals court there came to. Let me just tell you the facts. So, the facts are the vessel grounded whilst unberthing, whilst leaving the berth, causing loss and damage to her steering gear and necessitating the unloading of the cargo. Now, charterers alleged that they were not liable to pay GA, same as our case, and it involved the American Cogswell, which prevented recovery of GA if the vessel was unseaworthy, again unless the carrier exercised due diligence at the burden, at the start of the voyage. Now, if one turns to the report and looks at the top of page 3,
No, we don't have page numbers.
I do apologise. Can I ask you just to quickly number the report 1 to 6, pages 1 to 6? I do apologise.
Is that the page that begins Eusebius challenges the district court's holding?
So if page 3 is yes,
Okay,
that's page 3.
right.
And at the top of page 3, I do apologise it wasn't numbered. At the top of page 3, you'll see number of arguments. Burden of proof is A first, and we'll maybe have to come back to that later. B. Second, Eusebius claims that any error in navigation that causes damage to a vessel prior to the commencement of a voyage should be considered a lack of due diligence, and therefore the vessel owner is not entitled to general average. Now, what they go on to hold between the paragraphs just above the second hole punch, starting at Eusebius, assert that the district court erred in finding that Scandia had.
So where are you reading from, Mr.?
It's just above the second hole punch.
Yeah.
Starting Eusebius asserts that the district court erred in finding that Scandia had proven navigational managemental error. Eusebius claims that the voyage had not yet commenced and that the navigational management errors that occurred before the commencement are best viewed as a feature of the carrier to exercise due diligence. Under this view, Cogswell would only accept navigational management errors that occur after the voyage has commenced. Now, my lords, just jumping ahead, let me just tell you the error, my lords, and you'll see it as we go through in a moment. The error was that there hadn't been a master-pilot exchange prior to unberthing, and that it was said that this was a failure by the master in navigation and it rendered the vessel unseaworthy. You'll see that in a moment. Next paragraph. We see no reason to restrict the navigational error exception to errors occurring after the commencement of the voyage. We therefore agree with Scandia that Cogswell,
Shipping Company of India.
Yes, sorry, I do apologise. That Cogswell accepts navigational errors regardless of whether they occur before or after the voyage commences and do not reach the question of whether a voyage had commenced in this case. Now, if you then turn over the page, so he deals with their first complaint, it happened before the voyage. One then goes over to page 4. But just under the first hole punch. Prior to discussion of the commencement of the voyage, prior to its discussion of the commencement of the voyage, the Mississippi Shipping Court, that's another case that was referred to them, noted that both parties had agreed that the hull was caused by the negligence in the navigation of the vessel. The parties had both conceded that, unlike the former days of the Harter Act, when its Section 3 error in management exception was confined to events occurring after the commencement of the voyage, Cogswell Section 4.2a, which is the same as ours, is now unconditional both as to due diligence and point in time. The Mississippi Shipping Court then went on to consider the result of the case if the cargo had been immediately damaged by the inrush of water and noted that Section 4 defence would have been absolute whether the ship was deemed to be on her voyage, making ready for her voyage, or simply undocking preparatory to commencing the voyage. In other words, the Mississippi Shipping Court expressed an opinion on the resolution of the issue presently before this court. Mississippi Shipping's consideration of the issues presented here is dicta. However, we find its reasoning persuasive and adopt its approach and resolution to the present issue. Eusebius seeks to have this court declare that any navigational error that occurs prior to the commencement of a voyage results from a lack of due diligence to make a ship seaworthy. Cogswell's exception for navigational managemental error, however, is not restricted to navigational errors occurring after the commencement of the voyage. The plain language of the statute accepts the carrier for liability for damage caused by act, neglect, or default of the master mariner, pilot, or the servants of the carrier in the negligent management of the vessel. And so what he's saying is, Article 4.2a is clear. There is no division, or temporal division, as to when an act of navigation can accept you. And it doesn't lose its legal character because it's before the commencement of the voyage. Now, we're going to come on to now the seaworthiness point in this case.
Right.
Now, the court goes on to consider whether or not the vessel was unseaworthy. And you get that if one turns to the next page, page 5. By the first hole punch, it sets out the three grounds, that paragraph sets out the three grounds in which it said the vessel was unseaworthy. And I'm reading the last couple of sentences. Euseminas claims that the Jalaviha was unseaworthy in three respects. The posted lookout had duties in addition to the lookout and therefore was not competent lookout. 2, there was not a dedicated radar monitor. And 3, Cindia company policy does not require the master to discuss routine turning manoeuvres with the pilot. And what happened was the whole unberthing operation hadn't been pre-discussed with the pilot before she went off. Now, one then reads, the next paragraph. Euseminas initially argued that the master's failure to discuss the manoeuvre with the pilot was an unseaworthy condition which caused the grounding. Cindia, however, correctly states that in Avondale, a panel of this court found that the master's failure to adequately discuss the manoeuvre constituted negligence on the part of the master. Any negligence of the master concerning the movement of the vessel would be considered a navigational or managemental error and not an unseaworthy condition. Euseminas' response to this argument is that Scandia's lack of company policy requiring the master to discuss routine manoeuvres with the pilot constitutes an unseaworthy condition. So they fall back on the policy argument, on the systems argument. First, however, Euseminas must show that the district court was incorrect in rejecting a failure to discuss as a cause of the grounding. And then they go on to consider a causation.
In fact, it went off on an issue of causation.
It goes off in the end on an issue of causation. But the point is clear there.
So the specific point wasn't actually argued because the Euseminas had accepted before the Court of Appeals that a previous decision, that's the Avondale case, had held that failure to discuss manoeuvres with the pilot was negligence in the navigational management of the vessel and not unseaworthiness within section 3.1 of the US Concept.
They accept that that was a result of that case. They then say, also, in any event, we're going to run systems. And what the court actually then goes on to consider is also causation.
But what this court is not deciding, as I read this judgment, is that merely because something which can be categorised as an act of navigation or management of the vessel, because even though it occurs prior to or at the commencement of the voyage, it does not follow from that it may not also be unseaworthiness.
On the contrary, it seems to propound a dichotomy. It's either negligence or unseaworthiness, and it can't be both. Whereas you accept that at any rate on some facts, errors of navigation could render a vessel unseaworthy.
No, I don't think that's a fair reading of the report. What I would say here is, there is no suggestion here by the Court of Appeals, in this case, that approach of a failure to discuss with the master, pilot, the exchange, was, there's no suggestion that was not an error in navigation and it rendered the vessel unseaworthy. The court doesn't in any sense give any credence to that suggestion. In fact, what the court says is the case ended up having to be re-argued on the basis of it was a systems failure, that their company policy didn't require the systems. And what we say, my lords, is essentially, my lord, what this shows you is that
well, I think one really does have to be very careful. If you look at under the heading of C, just before the first hole
Yes.
punch on page 5, the end of that paragraph, therefore Usiminus may only prevail on appeal by proving that the district court erred in finding that Cindia exercised due diligence to make the vessel seaworthy and that an unseaworthy condition was the concurrent cause of the grounding. Then they go on to say that the district court determined, in fact, that the vessel, the voyage had commenced. And then they say,
So they wrongly
which
found
they didn't overrule, as I read the judgment. We also, he goes on to say, we uphold the district court's finding that the alleged unseaworthy conditions didn't contribute to the grounding. We decline to reach the issue whether the voyage had commenced. So what the Court of Appeals says is whether the district court was right or wrong in saying the voyage had commenced. We agree with them on absence of causation.
I agree.
So that's the basis upon which they refuse or dismiss the appeal.
I agree with that. I
The rest of
agree
it's
that
able to
the
do
I agree with that. I agree that causation was, in a sense, the touchstone there. They said you can't show causation, so that's it. But what I use this case for is to show that actually, I'll give you a good example. Under passage planning, that was in force in 1997, because our guidelines came in 1999. Passage planning that was in force in 1997, I won't take you to it, but it's in the authorities bundle, supplementary authorities bundle, bundle 1. As part of passage planning, you are required to have a master pilot exchange of information for planning on what your manoeuvre is going to be and how you're going to perform the voyage. That is part of passage planning. And that act of passage planning in this case did not render the vessel, we say, unseaworthy. It didn't lose its character as an act of navigation, which would entitle you to the defence of Article 3, Rule 4, Article 4, Rule 2A. And you shouldn't somehow try to expand the scope of unseaworthiness in Article 3.1 and force these sorts of factual cases into Article 3.1 and deprive a ship owner of his exemption, time immemorial exemption of Article 4.2a, because you're now saying, well, hold it, he didn't have a master pilot exchange, that was a defect. If you apply the McFadden test to that, would a reasonably prudent owner, listening to what's going on board the vessel at that time before she departs, say, there's a defect, you haven't had a master pilot exchange, and would a reasonably prudent owner say you shouldn't go to sea until you've had that master pilot exchange? And the reasonably prudent owner would say, yes, you must have that pilot exchange and you shouldn't go to sea. Therefore, but applying the McFadden test can simply give you the wrong answer in the case, because the fallacy is you've jumped over that stage, which is the defect an attribute of the vessel, or is it just an act of navigation which, as this court held, takes place before the commencement of the voyage, and it doesn't matter if it takes place before the commencement of the voyage, it's still an act of navigation. And that's how, this is a good example of how other jurisdictions see this, and other jurisdictions see this as, quite rightly, restricting the scope of or delimiting the scope of Article 3, Rule 1, because it's an onerous obligation, it permits to no exceptions.
Is there anything in the Avondale case that assists us as to the reasoning as to why the particular discussion between the master and the pilot, or absence of discussion between the master and pilot, did not amount to unseaworthiness? Because this case seems to proceed on the basis that the argument had been decided in an earlier case, and it's conceded by the cargo interests.
Certainly,
Actually, it's the earlier case that would help, not this one.
and we'll have a look at that over the short adjournment and see if we can give your lordships that.
It's the same circuit, actually, isn't it? It's 1996.
It is the same circuit, I think.
The first two of the three indicia of unseaworthiness, both were about the master's distribution of the crew, weren't they?
Yeah.
So you can ignore them.
Well, Well, you say we can ignore them, but why if you distribute the crew?
Not a proper lookout, not a proper monitor.
But if it happens before the commencement of the voyage and you apply the McFadden test, would a reasonably prudent owner say you should have a band who's a proper lookout? He would say yes. It all goes to my answer to their case, which you just can't blindly apply the McFadden test. You have to first say, what is the defect? What is the relevant defect? And is it one that goes to the attribute of the vessel, such that the McFadden test should be then used? And none of these defects, none of these navigational defects are
if you look at the last paragraph on page 5, the district court, the court below, had actually rejected the argument that the absence of a lookout and a dedicated radar monitor were unseaworthiness on the basis of causation. So they deal with it all on the basis of causation. Was the grounding caused by either of those two things? Which the answer was no, it wasn't. End of point.
They look at it. I accept they're dealing with the causation. What I'm trying to, and I've not suggested, and I hope I've not suggested.
So they don't. The court does not actually address head on. Was that unseaworthiness? Because it actually says none of the conditions that allegedly rendered the vessel unseaworthy were concurrent causes of the grounding. So we don't need to address the contention. Well, the district court erred in finding that Cindia exercised due diligence in preparing the vessel for the voyage. So they actually duck the unseaworthy.
I don't think they duck it, because if you go back, my lord, to page 4 by the second hole punch, what they're saying is they're not really ducking that answer. Can I suggest actually they're answering it in one sense? What they're saying in the paragraph next to the second hole punch is, Justinina seeks to have this court declare that any navigational error that occurs prior to the commencement of a voyage results from a lack of due diligence to make the ship seaworthy. Coxar exception for navigational managerial error, however, is not restricted to such navigational errors occurring after the commencement of the voyage. The language is plain. What they're saying there, my lord, with respect, is they're saying they're saying the court below is wrong, the submissions are wrong. It can be a navigational error within the meaning of Article 4, Rule 2A, even though it's before the vessel commences her voyage. And when seen in that context, I accept that the case was ultimately decided on causation, but when seen in that context, it's making, I say, the very sensible point, which is you cannot squeeze in navigational error into the ship owner's responsibility to exercise due diligence to make the vessel seaworthy. It's just navigational error. And I don't see why, I ask rhetorically, I don't see why a failure to have a pilot-master exchange, which is part of passage planning, should be any different from the second officer attaching part of the chart or writing on the top of the chart a navigational warning. It's all just part of, these are different acts, navigational acts, but they're all navigational acts. I've taken you through the Hill Harmony at some length, and I don't because that was going to be my final submission on that, which is essentially I've already made now, which is the same as the Jalaviha that we just looked at, which is the timing issue, where it doesn't cease to have the character of a navigational act, depending on where it happens or when it happens.
Right.
So, my lords, I know I've got very limited time, so I'm not going to deal with all of my learned friends' submissions on this now, because I've got limited time. I want to move on. I'll save some time in reply and come back if he picks up any of his points in his skeleton. Can I now move on to 2C in my roadmap, which is how the two principles work together? And this is just really drawing together now what I've already said. If we can do this with reference to my learned friend's skeleton argument on this, you can turn up that in the core bundle. it's tab 3. And if one starts at paragraphs 26 to 29, so I do apologise, tab 4, 26 to 29. And what my learned friend does is essentially make the point that my Lord Justice Haddon-Cave made in 26 to 29, which is the temporal distinction. And what we say is, we can now see why, with respect to my learned friend, that is wrong. An act of navigation does not cease to be an act of navigation just because it occurs before the commencement of the voyage. Then, if one goes on to paragraphs 30 to 38, what my learned friend does is, he in these sections, he gives lots of examples where there are acts in relation to the management of the vessel. They're not navigational acts, management acts that do affect the attributes of the vessel. And just running briefly...
logically, if the 42A exception is as it were, trumps in relation to navigation, it must trump in relation to management, mustn't it?
I accept that if, and I go back to the critical step we keep jumping over, if the error in management
these are all
affects
different
the
ways of
attributes
putting the
of
same
vessel.
point with respect, because if you're right in your primary submission that this is all navigation and cannot be unseaworthiness because it doesn't go to an attribute of the ship, then everything else that you've argued follows. But if you're wrong, and it is capable of constituting unseaworthiness because it goes to an attribute of the ship, then what these cases demonstrate is the fact that in other circumstances it might be within the accepted peril is neither here nor there.
Two
Do
responses.
you accept that proposition?
Partly.
Why only partly?
I'll
Why,
explain.
where do any of the cases
I'll-
draw a distinction
I'll-
between
I'll
management
explain.
on the one and navigation on the other?
I'll explain. As a matter of practice, okay, it is inherently likely, it's very likely, that an error in management of the vessel, because Article 4.2a requires it to be in the management of the vessel, not the cargo. It is likely, very likely, an error in the management of the vessel will affect an attribute of the ship. So it's not surprising that the only cases my learned friend can find and put before you, my lords, are errors in management of the vessel. It is inherently unlikely that a pure act of navigation will affect an attribute of the ship. It's inherently unlikely. My learned friend can only give one example, and that is the example of this case, namely passage planning. He can't find any other example where it's been held that an error of navigation is an attribute of the ship. There is no case. And he has to rely on a bootstrap argument and say, well, management navigation is no different, see the facts of this case. But that doesn't help because it's circular, it's a bootstraps argument. The reality is there is no other case in which an error of navigation renders the vessel unseaworthy. And it's not surprising, we say, for the reasons we've given. It's inherently unlikely because a master will produce lots of passage plans at lots of voyages on a liner service. There's nothing wrong with the intrinsic inherent attributes of that vessel if when he plans a particular voyage he makes a one-off mistake in navigation, in planning the voyage. Now, what I want to do is just jump forward a bit. I'm going to miss out paragraph 3 at the moment. I might come back to that after the short adjournment. I want to just do section 4 of my roadmap, which is such case law as there is, we say, all supports my submission. And the first one, my lords, is the Teare. And you'll have seen much has been written in the skeletons about the Teare, and you'll see it in the authorities bundle, tab 27.
The second one.
It's the second, yes. Now, there are two cases, my lord. It's the Teare and then the Jai Li Hai. Let's do the Teare first. The fact in this case is a grounding of a vessel. It's a bill of lading case, cargo of gasoline. The ship grounds on a voyage through the Magellan Straits, when she's got pilots on board, and the allegations were of a defective passage plan. My lords, at the time of the grounding, the ship was under pilotage, as I said. They had brought on board their own Chilean charts, which had not been available to the ship, and the planned course was marked on the charts, and the pilot's charts were being used for navigation. The ship, my lord, had produced its own passage plan, and it had been prepared before the commencement of the voyage, and this passage plan was pretty inadequate. You'll see what it said at paragraph 59. This passage plan, yes, paragraph 59 on page 544. The plan by the crew itself was written up in the vessel's planning register. This plan, as regards to that part of the passage between rendezvous with the pilots through the Gulf of Coronados, simply stated pilotage till Gulf of Coronados, 589 miles, without any wayports, courses to be steered or distances to be run. So they had their own passage plan. My lords, importantly, there was a continuing obligation of seaworthiness. You'll see it on page 551, paragraph 123 in the bottom right hand corner. So it doesn't matter that the pilots came on board halfway through the voyage. If the pilot's passage plan was defective, it was still unseaworthiness, because there was a continuing, paragraph 125, page 551. Yeah, paragraph 123, I'm being reminded. Continuing obligation of seaworthiness. Now, my lords, the pleaded allegations are important, my lord, and if you go to paragraph 30, it starts on the bottom of page 539, and you'll see over the page the relevant passage plan containing the allegations of, the relevant passage containing the allegations of unseaworthiness, as initially served, was notable for its lack of detail, but if you look at the particulars C, there was no proper passage plan for the part of the voyage during which the grounding took place. So this point that was fairly and squarely put in that case, namely that the vessel was unseaworthy simply because it did not have an adequate passage plan, i.e. nothing to do with systems. And then, my lord, so that deals with the passage planning. There were a number of criticisms about the pilot's passage plan that were brought on board, and you get that in paragraph 97. And you will see in paragraph 97 on page 549 three reasons why it was said that the pilot's passage plan was defective.
Where does the judge pick up the point? You said it's paragraph 59. That's to do with the passage plan of the vessel.
Yes, so there's two passage plans.
Where does the judge deal with the criticisms that the owners made? So the cargo interest made.
It's in paragraphs. Can I take you in a moment? It's at paragraphs 100 and 101. But I just wanted to show you the final criticism first, the allegation of particulars, and then I'll take you to it. And then if one looks at paragraph 39 on page 541, shortly before trial, there was an amendment of the particulars of unseaworthiness, and you'll see right at the bottom of the right-hand column, the particular C. It was not the master's practice to insist that navigation of the vessel was always based on proper passage plan, and or he did not properly appreciate the need to navigate by reference to a proper passage plan when a pilot was on board. So they ran the defective passage plan as a grounds of particulars of unseaworthiness, but substituted it later with a systemic failure type point in paragraph 30.
Well, it's to do with incompetence, isn't it?
Yes.
And that's Justice Teare dealt with this in paragraph 82 of his judgment and said that the defective or the improper passage plan was an aspect of incompetence. And that's the way the argument went. So that's why he concluded that you can't really derive much assistance from this case.
Oh,
It's the way to judge.
with respect, we don't. With respect, I don't think that is correct. Can I take you to paragraphs 100 and 101? I notice the time. Can I just go over by 1 minute, maybe, and just deal with, or would you prefer me to deal with this after the short adjournment? It could take.
Why don't you deal with it at 2 o'clock?
I'll do it.
Now, how are you doing? Because obviously this case is down for a day and a half.
My lord, I'm going to stick rigidly. I'm going to try to allow myself 15 or 20 minutes in reply, and I will take half the time to
So
sit
what's
down.
the answer to my question? When are you going to finish?
I'm not going to finish, but I will sit. When I say I'm not going to finish everything I prepared that I would like to speak about, but I will sit down and stop halfway through, leaving myself working
Halfway
out the
through
times,
what?
leaving myself. Sorry.
At what time this afternoon do you anticipate finishing your submission?
I was going to talk to my junior about how much time was taken initially on the procedural matters, but I was going to housekeeping should come out of both of our
Hang on,
times.
it's a simple question, Mr. Hill.
I don't know, my lord, the exact time. I would have thought about 3
You
o'clock.
must
I
have
think.
discussed this with Mr. Russell.
Yes, my lord.
What was the arrangement you made with Mr. Russell?
50-50.
3 o'clock, is it?
We agreed 50-50. We didn't agree how much time my learned friend was going to stop before halfway through to give himself time in reply. And I didn't bother to nail it down. It would be quite useful to know how much. Halfway through is 3:15. It'd be quite useful to know how much before 3:15 I have to stand up.
Well, we'll decide about 3:15. I don't see
I would
why
have thought
this is
that
my
Mr.
learned
Russell
friend.
and Mr. Hill that Mr. Hill should aim to finish his submissions by 3:15 at the latest.
Well, 3:15 is exactly the halfway, so that would leave no time for reply.
Well, I don't know about that. It depends how you deal with the earlier points, which we were going to look at. My lord, my learned friend criticises, but he shouldn't. It's my decision.
We're not
whether I
interested
have
in listening to
45 minutes in
criticism.
reply,
Mr. Hill.
20 minutes in
You're wasting time if you're going to spend time dealing with that. 2 o'clock, and we'll aim for you to finish your submissions by 3:15 at the latest. If you can finish by 3, that would be very helpful because they give us some time in reply. 2 o'clock.
Thank you, my lord.